Taxation. I'll try to be brief, touch on the major points, and I'll start and finish by saying taxation is a very, very complex issue, probably the most complex legal issue. You need to have a specific tax expert, accountant, attorney, whatever, to handle your tax situations. A concept I want you to go away with is what works for U.S. immigration purposes may not work for tax purposes. The best tax advice may not work for immigration purposes. So always best to coordinate between the experts. One of the first considerations we make is whether to form an entity in the U.S. as a subsidiary of the India company or as simply a branch office of the India company. Subsidiary is a separate legal entity, a corporation or LLC in the United States, a separate legal person from the India company, whereas a branch is the same company as the India company, merely located down the street in the United States, so to speak. So, a domestic corporation is a corporation that is created under the laws of any one of the 50 states in the United States. We call that a domestic corporation. Domestic corporations are taxed on worldwide income. In other words, they're taxed on income earned in the United States and income earned anywhere else in the world. It must be declared on a U.S. tax return. Treaties between the United States and the other country or countries generally will wipe out the effect of double taxation. Just another concept you need to remember, but leave it to the experts to work out the details. A branch office of a foreign corporation, in other words, a branch of your India corporation here, would be taxed on what we call ECI, or effectively connected income. And non-ECI income is taxed if it's derived from a U.S. source. Beyond that, check with your experts. Various treaties may give different rates. For example, branches pay something like 30–35% depending on the situation. The tax treaty between the U.S. and India may reduce some of that branch profit tax to just 15%. So, let's talk about something also relevant: tax on resident individuals. Talk about individual employees, maybe. All right. Individuals are the concept I want you to understand is, when are you a resident for tax purposes, and when are you not when you're a non-resident for tax purposes? Remember, it's different from the analysis of being a resident for immigration purposes and a non-resident. Temporary visa, permanent visa, different concepts. You can, because the tax authorities are so powerful and they want your money, you can be a resident and taxable on worldwide income long before you ever become a resident for immigration purposes. So who are residents for tax purposes in the United States? U.S. citizens, green card holders, and foreign nationals who meet what we call the substantial presence test. If you're considered a resident for tax purposes as an individual, you're taxable on worldwide income. And again, tax treaties will probably wipe out the double taxation effect. Under the substantial presence test, if you meet this test, all elements of the test, you become a resident for tax purposes and subject to worldwide income. First requirement, you have to be physically present in the U.S. for 31 days, at least 31 days in the current year, and physically present in the United States for a weighted average of 183 days over a 3-year testing period that comprises the current year and the 2 preceding years. So if you understand that, come up and see me and tell me about it. Educate me. I leave it to the tax experts. So, what it comes down to, after all the dust settles in your calculation, the weighting formula permits an alien to spend up to 121 days each year in the United States without becoming an income tax resident. All right? And again, you're not going to be a U.S. resident for tax purposes in any year that you spend less than 31 days in the U.S. Foreign investors who are not U.S. tax residents, not residents for tax purposes, are subject to U.S. tax only on U.S. source income. Other taxes that we need to be aware of, and you'll refer to your tax expert to advise you and handle requirements for these, are income tax on the company versus the individual. Unemployment tax, as Dr. Ziegler explained, companies have certain obligations. Unemployment tax, people can make claims if they're terminated from employment and collect unemployment tax. Employers have to pay that. So if you're doing business in the U.S., you need to be aware of your tax obligations. Social Security taxes, you will withhold and pay some of the Social Security tax obligation that the employer has to pay. Medicare tax, health tax. All right, so a big issue that comes up is, if you're moving employees to the United States, should you keep them on the India payroll or should you move them to the U.S. payroll for the purpose of tax purposes? Well, as a practical matter, this issue, this dilemma only comes up in L1 visa cases because H1Bs, professional employees, must be on the U.S. payroll no matter what. B1s, business visitors, cannot be on the U.S. payroll. They have to be on the foreign payroll, as we discussed earlier. So in L1 cases, you want to be careful because if the employee is in the U.S. on a prolonged stay, he can become a resident for tax purposes under the substantial presence test. And if the employee is engaging in certain productive work in the U.S., it raises the possibility that the office is considered doing business in the U.S. and income attributable to such conduct of business makes the branch liable for taxation. So again, tax planning with competent tax experts is critical when setting up a business, moving people to the United States. Export and import controls. Remember the good old U.S. CBP, the U.S. Customs and Border Protection Service? Those are the people at the port of entry when you get off the plane at the U.S. airport. They also regulate imports of goods into the United States. Licenses are required in certain cases. Again, another area where an expert in these specific fields is necessary. When you value goods coming into the United States, very, very important to give them a reasonable value. You can be fined otherwise and civil and criminal penalties for misrepresenting the value of what you import. Exports require licenses. Exports from the U.S. require licenses, general licenses and individual licenses. Again, you want to have specific legal counsel on exports. It's a very, very narrow and obscure field, so talk to the experts about that. Foreign trade zones may exist to get your goods close to the U.S. without yet becoming subject to the customs jurisdiction of the United States. You get your goods close to the U.S. to make delivery effective and efficient and timely, but avoids the regulation of the customs authorities until the last minute. The United States has certain free trade agreements with certain countries to give U.S. products and services a benefit over other products and services. The main ones that come to mind for immigration purposes are the North American Free Trade Agreement that involves U.S., Canada, and Mexico, and free trade agreements with Chile and Singapore, under which TNs can be obtained, TN status under NAFTA with Canada and Mexico, and H-1B1 visas, not H-1Bs, but H-1B1 visas, a separate quota for citizens of Singapore and Chile. And you don't have to do a pre-petition, but when the quota runs out, you have to wait till the next year, but it's more flexible than the normal H-1B quota. Citizens of Singapore, citizens of Chile. If someone is born in India but immigrates to and becomes a citizen of those countries, they could take advantage of that. It's not where you're born, it's what country you're a citizen of. Other areas where you need to be careful of legal issues that may come up with opening a new business in the U.S., I'll just touch on briefly. Product liability. If you're marketing goods or services in the U.S., if somebody is injured or harmed by your goods or services, your company can be forced to pay a legal judgment to cover the damages of the other party. This is called product liability. Various things you can do to prevent that, put clear warnings on your products, comply with all government regulations, and most importantly, educate your sales and marketing people to make sure that they don't say anything that's not true. The IT industry is a prime example of intellectual property. Software is intellectual property. Intellectual property is protected by various things, patents, trademarks, copyrights, and trade secrets. Intellectual property. You have certain remedies in case a competitor steals or uses unauthorized your intellectual property. You can go to court and sue for lost money, lost damages, lost profits, and you can possibly get an injunction or a restraining order against the competitor from continuing to do so. Antitrust and trade regulation. The United States has a policy of keeping competition and business open and fair. And anything that restricts the market, restricts free trade, creates a monopoly or something close to it, is regulated by the U.S. government. Antitrust claims can lead to money damages multiplied by 3 times. Get very, very expensive. Why do I mention antitrust? Well, because from an immigration standpoint, companies acquire other companies, companies merge in and out of existence. So if that acquisition or merger creates an antitrust situation, it can have an antitrust effect as well as an immigration effect. So you need to talk to antitrust attorneys on that issue to avoid the issue. Check before you do the transaction. Reporting requirements. The U.S. requires certain foreign investors to report the existence of the ownership interest to the United States government. So if a foreign person owns at least 10% or more of a company, there are reporting requirements and penalties for not reporting. Now, let's say you do all these things and you still get involved in a dispute with the government or with a competitor, for example. What do? Well, litigation is very, very, very expensive. And in my experience, in my opinion, even if you win the court case, you lose at the end of the day because it'll probably cost you much more to litigate than whatever it was you won. I used to be a litigator many years ago. So one way to avoid the cost and sometimes the risk is create or decide to go to arbitration. It's a process outside of the court system where an independent arbitrator will listen to both sides and make a binding decision. And you just don't do it in court. So you get an expert in the field to arbitrate it, an expert that you agree on. Maybe you can resolve a lot of the cost, save a lot of the cost.